In this lecture, I will discuss the provision of Section 167 of the Criminal Procedure Code. I have already discussed the Section 56 and 57 of the Criminal Procedure Code, and in that Section 57 there is a reference of this Section 167 of the Criminal Procedure Code. So I have already uploaded my video lecture on this Section 57 of the Criminal Procedure Code. Therefore, I request you also see that particular video lecture on this particular Section 57 of the Criminal Procedure Code, and after watching that video you will understand this particular provision now under Section 167 of the Criminal Procedure Code. According to Article 21 of the Constitution of India, no person shall be deprived of his life or personal liberty except according to the procedure established by law. Personal liberty is one of the cherished objects of the Indian Constitution, and therefore deprivation of such personal liberty can only be in accordance with the procedure established by law and in conformity with the provisions of law. So, Article 21 of the Constitution of India. Now we will see Article 22 of the Constitution of India. Its clause 1 says, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds. No person who is arrested shall be detained in custody without being informed of the grounds for such arrest. And no such person shall be denied the right to consult and right to be defended by a legal practitioner of his choice. So this Article 22 and Article 21, which forms part of the fundamental rights guaranteed under the Constitution of India, this Article 22 provides a very important right to the person arrested. First right is that under subclause 1, no person who is arrested shall be detained in custody without being informed of the grounds for such arrest, and another right that such person shall not be denied the right to consult and right to be defended by the legal practitioner of his choice. But for our particular topic of this topic under Section 167 of the Criminal Procedure Code, the subclause 2 of this Article 22 of the Constitution of India is very important here. It says that every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time which is necessary for the journey from the place of arrest to the court of magistrate. And no such person shall be detained in custody beyond said period without the authority of a magistrate. So this is very important subclause 2 of the Article 22 of the Constitution. It is also guarantees right to the person arrested. So similar provision is also there, similar to that this particular clause 2 of Article 22 of the Constitution of India. Similar provision is also found in Section 57 of the Criminal Procedure Code. Section 57 of the Criminal Procedure Code also says that no police officer shall detain in custody a person arrested without warrant for a longer period, longer than under all the circumstances of the case is reasonable, longer than the reasonable, and such period shall not, in the absence of special order of magistrate under Section 167, exceed 24 hours, exclusive of the time necessary for the journey from the place of arrest to the magistrate's court. So this is Section 57, on which I have already uploaded my special lecture. So I request you please see that lecture. So Section 57 says that no police officer shall detain in custody a person arrested without warrant for a longer period than which is reasonable, and such period shall not, in the absence of any special order of a magistrate under section 167, such period shall not exceed 24 hours, 24 hours exclusive of the time which is necessary for the journey from the place of arrest to the court of magistrate. And therefore, when an accused person is detained in the custody of the police after arrest beyond 24 hours, excluding the time taken for the journey from the place of arrest to the court, then such detention beyond the said period of 24 hours is surely illegal. It is illegal detention. So when accused is detained in the custody of the police beyond such 24 hours, then such detention beyond such period is illegal. Now, we will see the exact provision of section 167 of the Criminal Procedure Code. Its heading is procedure when investigation cannot be completed in 24 hours. 24 hours means directly, indirectly, police are authorized to keep the arrested person in their custody for initial maximum 24 hours, and when the investigation cannot be completed in that initial first 24 hours, then what is the procedure next? So section 167, its subsection 1 says, whenever any person is arrested and detained in custody and it appears that the investigation cannot be completed within the period of 24 hours as fixed by section 57, and where there are grounds for believing that the accusation or information is well founded, then the officer in charge of the police station or the police officer making the investigation, if he is not below the rank of sub-inspector, such police officer shall forthwith, immediately transmit to the nearest judicial magistrate a copy of the entries in the case diary relating to that particular case, and such police officer shall also at the same time forward the accused person, that is arrested person, to such magistrate. So this is a subsection 1 of section 167. Then subsection 2 says, the magistrate to whom an accused person is forwarded under this section may from time to time authorize the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days in the whole. So magistrate is authorized to grant the police custody of that accused person from time to time, but the whole period of such police custody cannot exceed 15 days in the whole. So the magistrate to whom an accused person is forwarded under this section may from time to time authorize the detention of the accused in such custody as such magistrate thinks fit for a term not exceeding 15 days in the whole, provided that. So there is a provisional clause, provided that there are two important clauses, that is clause A and clause B, under the subsection 2 of this section 167, which provide the provisional clause. It is a provisional clause. So I will read the clause A. The magistrate may authorize the detention of accused person otherwise than in the custody of the police beyond the period of 15 days if he is satisfied that adequate grounds exist for doing so. So after the initial period of police custody of 15 days, after expiration of initial period of police custody of 15 days, this clause A says that the magistrate may authorize the detention of the accused person otherwise than in the custody of the police. Otherwise than in the custody of the police means now it is a judicial custody or magisterial custody. The magistrate may authorize the detention of the accused person otherwise than in the custody of police beyond the period of 15 days if he is satisfied that sufficient grounds exist for doing so. But to this particular power of magistrate, there are some restriction. What is that restriction? But no magistrate shall authorize the detention of accused person in custody even judicial custody or magisterial custody. But no magistrate shall authorize the detention of the accused person in custody under this provision for a total period exceeding 90 days exceeding 90 days, where the investigation relates to an offence which is punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years. And in case of other offences, provision is such: no magistrate shall authorize the detention of the accused person in custody under this provision for a total period exceeding 60 days, 60 days, where the investigation relates to any other offence. That means here, for the purpose of this particular provision, offences are classified into two categories. First category is such where such offence is punishable with death, punishable with imprisonment for life, or punishable with imprisonment for such a term which is not less than 10 years. Means at least imprisonment for at least 10 years or upward. This is the one category of the offence. And another category of the offence, any other offence, means punishable with any other punishment. For example, if it is a punishment of imprisonment, then it is less than imprisonment for a term which is less than 10 years. So in case of this second category of offence, we have to remember the 60 days, and in case of first category of the offence, we have to remember the 90 days. So I read this provision again. But no magistrate shall authorize the detention of accused person in custody which may even judicial custody or magisterial custody. But no such magistrate shall authorize the detention of the accused person in custody under this provision for a total period exceeding 90 days, where the investigation relates to an offence which is punishable with death, imprisonment for life, or imprisonment for a term of not less than 10 years. Similarly, no magistrate shall authorize the detention of accused person in custody under this provision for a total period exceeding 60 days, where the investigation relates to any other offence. And after the expiry of said period of 90 days or 60 days, as the case may be, the accused person shall be released on bail. If he is prepared and does furnish the bail. If he is prepared to give bail, and if he furnish the bail, then such accused person shall be released on bail on the expiry of said period of 90 days or 60 days of his custody, as the case may be. So, in terms of practice, in the language of practice, lawyers call it as a default bail. It is a default bail. Default means that within that prescribed period of 90 days or 60 days, as the case may be, police has made a default in not completing the investigation of that offence, and police has made a default in not submitting the investigation report, that is charge sheet, before the magistrate. Therefore, during whole this period of 90 days or the 60 days, as the case may be, if suppose such accused person is in judicial custody, then he has a right to get released on bail. Then the clause B of subsection 2 of this section, section 167 of the Criminal Procedure Code is also very important. It says that no magistrate shall authorize detention of the accused in custody of the police under this section unless the accused person is produced before him produced in person for the first time, and also subsequently every time till the accused remains in the custody of the police. So, police must produce the accused person in person before the judicial magistrate while they are asking for police custody they are asking for extension of the police custody again and again. So, accused person must be produced before the judicial magistrate by the police when they are asking for police custody remand of such accused person from time to time. So no magistrate shall authorize detention of the accused in custody of the police under this section unless the accused is produced in person before the magistrate for the first time and subsequently every time till the accused remains in the custody of the police. So generally, when before expiry of the initial period of 24 hours, before expiry of the initial period of 24 hours, it is mandatory for the police officer who has arrested the accused person to produce such accused person before the judicial magistrate. And if the investigation has not been completed within those initial 24 hours, then police prays before the judicial magistrate for police custody remand of that accused person. So generally, judicial magistrate grant at one time, at one single incidence time, police custody remand of such accused person for 3 days, 4 days, for example. And after expiration of those 3 days, 4 days, again the police officer has to produce that accused person in person before the judicial magistrate. And when the police are praying for the extension of police custody remand, then in that case, again judicial magistrate may grant further police custody remand for further few days, for example 3 days, 4 days. But the total period of such police custody remand, total period cannot exceed 15 days, cannot exceed 15 days. Therefore, after the expiry of those total period of 15 days of police custody remand, if the magistrate thinks that that accused person should not be put further in the custody of police, but he should not be even released, then magistrate grant the judicial custody, magistrate grant the magistrate custody remand MCR to that accused person. So this clause B says when initially after the expiration of that initial period of 24 hours after the arrest, when police officer, when the accused person is in the custody of that police officer, then that police officer has to produce such accused person in person before the magistrate. And when from time to time subsequently, when such police officer is asking for or praying for police custody remand of that accused person, then on every occasion such accused person should be produced before the magistrate in person. But what about the case when that accused person is now in the judicial custody or magistrate custody? That provision clause B further says, but the magistrate may extend further detention in judicial custody of such accused person on production of the accused person either in person or through the medium of electronic video linkage. So when the accused person is already in the judicial custody, that means he is not in the custody of police. And for extending the magisterial custody remand, it is not necessary that or compulsory that said accused person should be produced before the judicial magistrate in person. Now he can even be produced before the judicial magistrate by way of video conferencing. Then thus section 167, especially subsection 1 of the Criminal Procedure Code, section 167 of the Criminal Procedure Code is the law which regulates and empowers a magistrate to authorize the detention of the accused either in police custody or in judicial custody as the case may be. While passing an order of remand, either judicial custody or police custody, since because said detention, passing of remand means accused will be kept in detention. While passing an order of remand by the magistrate, since because such detention deprives the personal liberty which is guaranteed under Article 21 of the Constitution of India, such order of remand shall not be passed in mechanical fashion. The magistrate is required to apply his mind into the entries in the case diary relating to that case, entries relating to investigation. The magistrate is required to apply his mind to the entries in the case diary, representation of the accused person and other facts and circumstances, and only on satisfaction that such remand is necessary, the magistrate shall pass such order of remand. So this is the very important provision under section 167 of the Code of Criminal Procedure Code. So I stop here. Thank you.